everybody, this is Sean Riley with Riley Real Estate and MassHomesale.com with this week's Q&A Saturday video. This week I'm going to be answering the question of what is the due on sale clause. So the due on sale clause is something that's in pretty much all of your standard bank mortgages, which says that if you transfer title to the property, that the note securing the mortgage for the property is going to be due upon the sale, whatever that might be, of the property. This came about mostly in like the early 1980s. For those of you who are my age or younger and don't actually remember what things were like back then, it was that's when you'll hear the stories about like interest rates on just regular mortgages being double digits, like 10, 11, 12, 13, 14%. So it was very common at that time for people to sell their houses subject to the existing mortgage that they took out earlier in the 60s or 70s or whatever, where the interest rates were much, much lower. So banks didn't like the fact that they were losing out on generating new mortgages at double-digit interest rates. So it became standard practice to put these clauses in mortgages, which basically said you shouldn't be selling them subject to the existing mortgage anymore. People still did it. People still do it. But there is the risk that the loan could get called due. Investors especially still like to buy property subject to. We actually did a video a while back on seller financing and specifically subject to financing, and wrap mortgages and stuff like that, which are sort of a offshoot of that. We'll link to all of those below, but we'll talk about that a little bit again here. So if you buy a property subject to, you are technically violating the due on sale clause, and there is a chance that the bank could find out, and then there's a chance if they found out that they would call the loan. It definitely happens. I've heard of it happening to people, but most of the time it doesn't. So it's definitely a risk. It's not a huge risk. But if the bank does call the loan, basically somebody would need to either refinance the loan, sell the property to somebody who will pay off the loan. Sometimes you can transfer title back to the original owner, in which case the bank will typically stop the foreclosure process. Not necessarily, but usually. Or the house goes into foreclosure. The person who purchased the house will lose the house. They'll lose anything they put into the house. But the original owner, who the note is in their name, will actually be the one with the foreclosure going on their record. So that's the big risk there. So anybody buying a home subject to, or some various form of it, should definitely be aware of the due on sale clause. They should make the person they're buying from understand the due on sale clause and that there is a risk involved with it. And they should basically have the means to either pay off the mortgage or refinance the mortgage or be able to sell it quickly to avoid the foreclosure process. So they're not putting the person they bought the house from at risk that way. I am talking investors. Regular people can buy it too. It's just that most retail buyers aren't really even aware that they can do this kind of stuff, and it doesn't come up very much. Especially these days when interest rates just seem to keep going down. Now they're more of a plateau and they kind of bounce around and stuff. But there's not some huge advantage to taking a mortgage generated a couple of years ago at 3% versus getting a new one right now at 3.5%. It was a much bigger deal. Said back in the 80s when you would be getting a new mortgage at 13% and you could get one that was at 7%. So that's a huge difference. So that's why people were doing it. Excuse me. So it's also important to understand that doing something subject to, it's not illegal. It just violates the contract that you had with the bank, this clause that's in it. So the bank has the right, but not the obligation necessarily to call the loans. So that's what I'm saying. Most subject to transactions never have a problem. They just can because it violates the contract, so the bank has the right to call it. But if you look at the old HUD-1 statement, in the video on subject to, we actually highlighted this section. There's actually like a line on the closing statement that says, loans taken subject to. So it's a very common practice to the point where they actually have a line for it on the HUD-1 statement. Now that we have the new TRID guidelines, I haven't looked at the forms enough. I'm actually not totally sure if there is a section on there for that, standard or not. But it doesn't change the fact that like I said, it's not illegal. There's no, as people say, no due on sale jail. But like I said, it violates the contract, as does many other things. So the bank could call the loan. So that's, like I said, that's the main thing with the due on sale. Other things that come up sometimes is if you own the house and you are going to transfer the deed to, that comes up a lot for estate planning. So you'll see people, those $1 sales where they sell the house to a trust that they have for estate planning and stuff like that. There are some laws that went into place that allow you to do that for estate planning. Sometimes people kind of stretch the truth on that. Like people who are selling to investors and whatnot, they put it in a trust, they sell the trust. It's not really for estate planning, but they use that to kind of get around the due on sale stuff. It's a little complicated. It's sort of stretching the truth. Again, I'm not a lawyer. I'm not saying any kind of legal opinion, but it's a little more iffy. But for those of you who just are transferring title into a trust for that you own and are planning on keeping, that actually should not violate the due on sale clause. Something that investors see sometimes is they buy a house or an apartment or whatever in their own name with a loan in their own name, and they later want to transfer it into like an LLC or something for asset protection, and that actually does violate the due on sale clause. And I've actually heard at least as many instances of where the bank tries to call that loan, even though it's still technically owned by the same person, because the person owns the entity in which they're transferring it into, as I've heard people having loans called that they've taken from other people. So that's something to be aware of. Again, on all of those instances, the people that I've heard from, they just transfer it back into their own name, and that clears away the problem. Or they pay off the loan, one or the other. Paying off the loan will always solve the problem. So that's the basics on what a due on sale clause is and how it relates to seller financing and deed transfers when you're selling to an investor with subject to or a wrap mortgage or something like that. Again, like I said, we've done some other videos on these subjects. I'll link to all those below. And as always, if you have any other questions or comments, please put them below. And if you have any topics that you'd like to see in a future video, always feel free to post them on our Facebook page, our Twitter account. Send an email to info@masshomesale.com, or you could just put them in the comments on any of our videos. So have a great week, everybody, and I will talk to you next Saturday. Thanks. Bye-bye.